Welcome to the Intellectual Property Law Teach the Class series. We will be focusing on dramatic works, asking the question, can copyright subsist in a dramatic work? A simple definition of copyright is that it is a property right of certain creative works. The scope of copyright law in Australia is defined in the Commonwealth Copyright Act 1968. Copyright protection is given to two classes of things, being works and subject matter other than works. In order to be capable of copyright protection, a work must be an original literary, musical, dramatic, or artistic work. As well as being original, a work must also be in material form. Therefore, copyright doesn't protect the ideas themselves, but rather it protects the expression of these ideas. Subject matter other than works is also capable of protection under Australian copyright law. This includes films, sound recordings, and published editions. Although not exhaustively defined in the Act, Section 10 provides that a dramatic work includes a choreographic show or other dumb show and a scenario for a film. Put simply, a dramatic work is any work that is intended to be performed. It must also be able to be performed. This may include a script or scenic arrangement, but it must be noted that this section does not include the film itself. To further understand this area, we will be discussing the cases of Green and Broadcasting Corporation of New Zealand, as well as 9 Network Australia and the Australian Broadcasting Corporation. In Green, the appellant, Huey Green, alleged that the British talent television show Opportunity Knocks had been copied in New Zealand. In this leading case, one which is famed for its brevity, the Privy Council upheld the decision of the Court of Appeal by refusing to consider a television talent contest as a dramatic work. Now, this was for 3 reasons. Firstly, Lord Bridge did not consider that repeated but unconnected features, including catchphrases and the use of a clapdometer to measure audience reaction, as a format. His Honour concluded that these features were not substantial enough to be considered a work. Secondly, the show's features express no more than a general idea or concept. As we have discussed, a general idea cannot be protected by copyright. Finally, Lord Bridge stated that a dramatic work must have sufficient unity to be capable of performance. His Honour concluded that Opportunity Knocks lacked this essential characteristic due to its unconnected features. To better understand the position in Australia, we'll be turning to the case of 9 Network and the ABC. In this case, Channel 9 brought an action against the ABC in an attempt to gain copyright ownership of the 2000 Millennium fireworks display at the Sydney Harbour Bridge. Justice Hill questioned whether the setting off of a fireworks spectacular was a dramatic work in the ordinary sense of the words. Now remember, a dramatic work must be in material form in order to be capable of copyright protection. It was concluded that there was no certainty that the event would run precisely to its schedule, with Justice Hill stating that there may be many a slip-up between the actual plan and the ultimate performance. The display was not considered to be a dramatic work, as it could not be reduced to material form without difficulty. We have learnt that copyright may subsist in a dramatic work under Section 32 of the Copyright Act. However, being classed as a dramatic work can be difficult. A dramatic work must be original and in material form in order to be capable of copyright protection. And lastly, as well as being intended to be performed, a dramatic work must be capable of being performed and must have sufficient unity. I hope you now have a better understanding of this area of law.